Good morning. Come on in. It's 9 minutes after the hour. It is the Voices of Montana on the Northern News Network. I'm David Berg, and now that the housework is done, let me introduce you to our newsmaker guest this morning, Lee Bruner, candidate for Attorney General. Lee, good morning. Are you there, Lee?
Hello?
Oh, there we go. Okay, great. I just didn't hit the right buttons there. Lee, the Supreme Court now has been talking about that Washington, D.C. case of guns and owning guns and that sort of thing, the Second Amendment, or the amendment that allows us to carry guns. We had kind of an update on that here a couple of weeks ago. At least we knew where it was going and what was being said. What has happened since then?
Thanks. We're 9 days past the oral arguments in the case. Oral argument was presented to the Supreme Court on March 18th, and it's now what we in the law call deemed submitted. And the discussion has really moved from whether or not the Supreme Court will recognize an individual right, whether a person has an individual right to keep and bear arms, to what is going to be the nature of that right. And there's, as an example, you have a constitutional right to own property, but that right is subject to what we call reasonable regulation. The government can zone your property. They can tell you if you can build a business there or if it has to be residential, if you can if you can drill a well there. They can do all that zoning stuff. There's another kind of right called a fundamental right, and those are rights like the freedom of speech, the free exercise of religion, and those rights are subjected to a much higher level of scrutiny, and we call that strict scrutiny. Is the government using the least restrictive method to achieve their aims? And so the discussion in this case has really moved to what kind of a right is the Supreme Court going to recognize? Is it going to be just a general right that the government can regulate and control and tell you what kind of guns you can have and where you can have them? Or is it going to be a fundamental right, which will give us a lot more protection?
And there's no way of knowing which way they're going to go, is there?
There is not, Dave. The Solicitor General for the United States, who basically filed the brief on behalf of the President and the Executive, argued for what we call the less restrictive, the reasonable interpretation argument. The attorneys who argued for Mr. Heller, who's the person who's taking our gun rights forward in that case, acknowledged that some regulation of guns would probably be allowed, such as the sale of machine guns. You're probably going to have some sort of restriction on those, be it licensing or those types of things. But the interesting question, it's going to be fascinating, and it's going to take years to figure out, is where are those lines drawn? What's allowed under the Constitution? What does that right protect, and what isn't protected? And nobody knows where that's going to go, Dave.
One of the things that they have to consider is something that the Founding Fathers did not consider, and that was the fact that guns are going to evolve too, like all technology. So whatever decision they come up with, if they're going to be specific, and sometimes the court is not specific, but if they're going to be specific, they've got to take into consideration now laser guns, death ray guns, that sort of thing, won't they?
Sure, and that's central to the argument. And what that's called is it's called the progression or the lineage of the particular item in question. Much like radio, at the time that the Constitution was drafted and the free speech provisions were put in it, nobody could visualize what you and I are doing today, talking from hundreds of miles apart and reaching folks all over the state of Montana. But that's the natural progression of the media and the press to this thing. So our speech today is protected by that First Amendment freedom of speech provisions. And the same thing is true of firearms. At the time the Constitution was drafted, we had smoothbore, single-shot muskets. But those have evolved and they have progressed. And one of the big questions is, are the weapons in question, do they fall into that natural progression and lineage that the Founding Fathers thought about?
Sure, because you've got all kinds of things to consider there. In fact, once we discussed this before here on the Voices of Montana, a caller called in and wanted to know if it was if owning a 105 howitzer was okay. Well, that's I guess it would be. I don't know, but they are going to have to draw the line somewhere and say, okay, a certain bore or a certain weight or some classification to draw the line if that's the way they go.
Sure, and even though this hasn't been publicly discussed a lot, I think in the back from the questioning in the oral argument, in the back of a lot of justices' mind is the they seem to be, especially Justice Kennedy seemed to lead the charge on this, was that one of the reasons that we have firearms and we're allowed to have firearms is to protect ourselves, to give us personal protection in our homes. And I wouldn't be surprised that the lines get drawn to meet that aim. Obviously, a handgun provides personal protection in the home. A long gun does the same thing. A howitzer does not. My wife would have a fit if I put a howitzer in my front room.
Yeah, you'd probably have a fit too if you did that. Lee, I appreciate you bringing us up to date on this thing. We just, it's one of those things where we just have to stay tuned, keep our eyes and ears open. And when do we expect a decision from the court?
We should get a decision in late June or early July, Dave. The Supreme Court on these very difficult decisions typically issues them at the end of the term. And this is a difficult decision because it's what we call a case of first impression. The Supreme Court has never really specifically addressed the Second Amendment before. There was a case called Miller years ago, but it doesn't really address the issue that's before the court. So I expect we'll see it in late June or early July.
Isn't that interesting? Because every other part of the Constitution has been scrutinized and re-scrutinized and put under a microscope and talked about and so on. I wonder why the right to bear arms has escaped attention for so long, over 200 years.
It has, and all the circuit courts, and in the federal system, there are three levels of courts generally. There's the United States Supreme Court, which of course is the top court in the land, and then there are the circuit courts of appeal, and ours is the Ninth Circuit, which sits in San Francisco, and then, of course, the state district courts, such as Judge Malloy sits at here in Montana. And the progression of a case is it goes to the district court, which is the Montana court, then it goes to the Court of Appeals, and then it goes to the Supreme Court. And until the Second Circuit, in this case, said there is an individual right to keep and bear arms, there wasn't a single circuit court that acknowledged that individual right routinely. So it's a fascinating time for constitutional lawyers and for those of us who believe that gives an individual right to keep and bear arms.
Lee, we'll wait for that, and I'm going to count on you to bring us all up to date on that when we do get a decision. Would you do that for us?
Thank you, Dave. I'll be watching it very closely. Call anytime.
Okay, Lee Bruner, thank you very, very much.